Affleck, this is on, I believe, for your motion. This is a motion for assignment of counsel.
That's correct, Your Honor.
And my issue, Ms. Affleck, just before we get too far into this, is this not the same as what Judge Bowie heard and ruled on February 28th and March 14th?
The reason why I'm bringing the motion, Your Honor, is because there was, number one, there was no motion before the court. What had happened is there was a motion from Daniel Ehrlich to withdraw as counsel. And then on that Friday before the Monday hearing, Carolyn Miller, the prosecution, provided Daniel Ehrlich a response. I was not given a copy of that response. And then on Monday, we show up at court and I asked for a copy of the response. And that's prior to the motion being ruled on.
This is a motion, this is Mr. Ehrlich's motion to withdraw that we're talking
Yes,
about.
that's correct.
Okay.
No other motion was before the court. So then we show up and I'm you know, and I asked my attorney here in court, which I shouldn't have had to have. I had to ask him if he had responded to her response or replied. And he said he had not done anything with it. And so then I was a little bit alarmed because here he's going to withdraw for conflict, and then she's providing him the notice, but I don't get the notice and he doesn't respond. And so that kind of leaves me in a position where nothing has been replied on. So I had made that comment that they shouldn't consider her response because I wasn't able and he did not respond to it or reply to it. So what had happened is Judge Bowie went ahead and orally ruled on that motion to withdraw and allowed him to leave the case. That left me without an attorney, no representation. Then, and over my objection, and then the prosecution wanted to have a ruling, like she wanted to turn her response into a motion at the court, which I was a little concerned, and I brought up objections that it's mute. They've already ruled. They allowed him to withdraw. And what had happened was Judge Bowie did not appoint a new attorney under 3.1. If she's going to allow an attorney to withdraw, she must reassign a new counsel. So what had happened was she didn't reassign a new counsel, left me without counsel, and then ordered me to respond to her reply to her response. And so at that next hearing where I'm thinking that, oh, why are we having this hearing? There's no motion.
That hearing being the one, just so I'm tracking with you, that would have been now we're talking about the April 8th,
March 14th.
March 14th. Okay.
So that's at the March 14th hearing. So then, at that March 14th hearing, I'm confused at what we're there for. So I'm filing what she ordered me to, and I'm appearing because I'm ordered to. I have no counsel. I had nobody to help me with the decisions making in my defense. Being just a couple months ago, Judge Bowie said that I could go to prison for 6 years for responding to a court in 19-201-82031 when there was a pending hearing. So what I was confused about is that this district court knows that there is an ongoing Superior Court case relating to these parties and this issue. And the district court shall transfer under 10-14-150, I believe it is, that if they are aware that the situation is in another Superior Court, they shall transfer this case. And I don't understand why this is being severed from the actual case, because if in fact I did violate that, it would have been a contempt, which should have been before the judge who issued the anti-harassment order. Here what they're doing is they went to Evergreen District Court. She applied for a domestic violence anti-harassment order, charged me for a domestic violence order. The order was never signed on June 20th, 2020. And then here we are in April now of 2022. My arraignment did not take place until October of 8 months after she had charged me with domestic violence. And then like a week or so prior to the arraignment, she changes it to anti-harassment with no police report or any investigation supporting what she's claiming I'm violated with. So the super form says domestic violence. I've never had a domestic violence issue.
Okay, so
like that.
as to what brings us here today, though, it looks like Judge Bowie on the 14th, I wasn't here, and I'm not Judge Bowie, but it looks like what was ruled upon was your motion to dismiss for failure to provide counsel. I believe that is what you were asking, and it was in the context of that motion that Judge Bowie had made a ruling about your forfeiture.
Do you have an order?
I have the docket notes, and there's an audio report.
There's absolutely no order. Okay, that prevents me from an
There's been a
appeal.
verbal order.
Oh, so let me go back. I did not file a motion. I was ordered to appear here for her response. That's why we showed up.
On the 14th.
Yes, that is the order, and that will be reflected in the video. You can go on YouTube if you want. It's posted on YouTube, the whole hearing. I was ordered to appear here for responding or replying to her response. Is that correct?
Okay, I'll hear from Ms. Miller in just a minute.
Okay, so what I'm here for is I'm asking for a motion for assignment of counsel. The way that the procedure happened was improper. I was not provided any counsel in order to support me with whatever I did. So anything I did should have not been considered. And I want to address her reply real.
Well, before we get to that, just because I can only make a ruling on matters that are properly before me, and so
I'm going to reply to this.
let me just ask, so Ms. Miller, just as to the procedural posture of this case, what's your understanding of what is being asked of the court today? What is the motion before the court?
The city, after we filed our motion, became aware that the defendant filed a motion for assignment of counsel on April the 11th, and according to the court record, she originally noted it for the middle of May, which is not a motions date, so it was re-noted for today. So the city's position is that while we responded to a motion, we responded to her motion to dismiss for failure to provide counsel that was dated March the 7th, pursuant to email confirmation from Ms. Shablick last week. We did subsequently receive a motion she filed with the court for her motion for assignment of counsel. City's position is that all of these issues were addressed at the hearing on March the 14th by Judge Gideon, because most of what is put in writing here is reflected in the oral recording, because these were arguments Ms. Shablick made at that hearing. As Your Honor is aware, a written ruling is not necessary in district court, but rather the record in the audio recording are Judge Bowie made detailed ruling that day, going through the case law of the limitations of Gideon versus Wainwright and why she found that Ms. Shablick's motion, that Ms. Shablick had waived and forfeited her right to counsel. The city's position is that...
To assign counsel.
To assign counsel. The city's position is that we correctly filed a response to Mr. Ehrlich's
motion of
withdrawal. Then Judge Bowie afforded Ms. Shablick an opportunity to respond. At the time we served Mr. Ehrlich our response, he was still counsel of record for Ms. Shablick. So
I understand why he was the response.
So the city's position is that even though we filed a written motion, not having seen the motion that was filed on the 11th, our argument remains the same, is that these issues are removed and have been addressed by Judge Bowie previously.
All right, and then Ms. Shablick, I have a question for you, and it does go to the merits of what you're asking of the court, but it looks like you do have a pending round appeal, and you filed a notice of appeal on March 17th, appealing Judge Bowie's February 28th and March 14th rulings. So just yes or no, am I correct on that? Because I got that from just looking at the Odyssey portal for Superior.
The appeal was filed, that is correct. Judge Bowie ordered that I not file anything in the case without an attorney. I don't have an attorney, so what she did was she blocked me from being able to get clerk's papers. They told me that it was going to be $1,000 or more to get the copy of the case. I'm waiting on that, and so yeah, there is an appeal on a different matter. However, removing my counsel.
No, there's an appeal on this matter.
No, not on this matter. Your Honor, there is nothing on appeal about assigning me a counsel. Now, what happened was Judge Bowie took away Judge Nguyen's order. Judge Nguyen issued an order assigning me a counsel. The court clerk leaned over and said, well, she has to be approved for it. Judge Nguyen said, nope, I'm appointing JNF. I'm appointing him. And so if she's going to take that right away from me, it should be before Judge Nguyen, number one. And number two is that she cited a case in front of Bowie that I later looked up. And City of Tacoma versus Bishop is a Division I case, a Division II case that may be persuasive argument. However, it's not case law. She has not provided any case law relating to me being able to withdraw or me being able to have assigned counsel. So here you have Judge Bowie. I don't know why she's not here today, but that order the motion for assignment of counsel is because there's never been a motion before the court. It was only on her response. I was ordered to show up and respond to her, or reply to her response. There has been no calendar note, there has been no motion. And I want an order. I want an order because I want them to issue me a counsel. I want my counsel to write the reply. I want the counsel to represent me. And if at that point, it's determined.
You want counsel to write the reply to, because I thought the motion where there was an absence of a response, you didn't get a copy of the response until the day of, that was Ehrlich's motion to withdraw.
So Ehrlich motion to withdraw, she replied. So Judge Bowie came in and severed. She said, okay, I'm going to grant your motion, but Ms. Shavlik, you're going to not have an attorney, and I want you to come into this court, and I want you to reply to her response. I did that without counsel. That is not fair.
Okay. So here is what I'm going to do today. From my review of, and I want to make sure the audio record is clear so that, if I'm wrong, you can point that out to a reviewing court. But it does appear that there is a pending route appeal that encompasses the matters that are before the court today.
That is not true, Your Honor. These happened March 14th of 2022.
And then on March 17th of 2022, you filed a notice of appeal under that Superior Court case number 21-1-00483.
Give that to me one more time.
21-1-00483-31 is where it appears that you filed a notice of appeal taking issue with Judge Bowie's rulings on 2/28 and 3/14 of 22.
On March what?
On February 28th and March 14th. And that portion of your notice of appeal was filed on March 17th, so a few days after Judge Bowie's 3/14 ruling.
Okay, I want to point out to this court those dates, February 28th and March 14th, I was without counsel.
My point being that there is a notice of route appeal that encompasses what Judge Bowie ruled on February 28th and 3/14. And there are rules of appellate procedure for appeals from courts of limited jurisdiction. Route 4.1b is in Bravo, presumptively says that it presumptively limits the authority of the district court to revisit matters that are pending on appeal in Superior Court.
Your Honor, does that mean you're dismissing this case?
No.
If I'm going to continue on this case, I need an attorney.
I know, and I'm also looking, again, I wasn't here, but according to the docket and the audio record, it appears that after Judge Bowie approved the withdrawal, she said you had forfeited your right to assign counsel, not your right to counsel. and then the matter was continued so that you could retain private counsel.
I don't have the amending shoe.
Okay, so that argument, that whole thing about assigned counsel is what Judge Bowie already ruled on. And so I'm not the appellate court that can overrule her. I'm not saying whether you were right or wrong at that 314 hearing, or, it's entirely possible that the Superior Court,
well,
don't
Your Honor,
interrupt me while I'm talking.
I just want an order.
Don't interrupt me while I'm talking. So it's entirely possible that the Superior Court is going to side with you and say Judge Bowie made an error, or they're going to side with the city and say that Judge Bowie is affirmed in her March 14th ruling. My point is that I do not have authority to revisit the issue of whether you forfeited your right to assign counsel. So
I want an order. That's all.
I just issued an order.
Thank you. I want it written.
Well, you don't get it written. It's with the court of record. We're being audio recorded.
Does anyone else here get a written order? Or is it just me?
Okay, so
Just me?
I've made my ruling.
Okay.
That's my verbal ruling. And Ms. Miller, is there a next court date that we are?